Hi, I'm David Herzog. I'm a business, real estate, and tax lawyer in the San Francisco Bay Area. My clients are small businesses and startup companies, many of whom are internet and tech-based. In this video, I'll take a little time to instruct you in the ways of buying and selling a small business. Let's start with your initial exchange of information or ideas, whether it's with the buyer or the seller or family or friends. You should have a non-disclosure agreement in place called an NDA. NDAs don't stop people from blabbing and sharing, but they do put those folks on notice that they're going to be looking down the wrong end of a fire hose if they do. NDAs are a simple way to protect yourself up front. They also show that you're serious and savvy. Once negotiated, you can put some terms in a letter of intent. The letter, or LOI, is not an agreement, though some LOIs have terms that you are bound by, such as the seller agreeing that they won't deal with another buyer for a certain period of time. During the LOI period, you might exchange information such as financials, tax returns, books and records of the business, etc., which you should be able to do if you have a signed NDA. You might also go directly to entering into an agreement. How you proceed will depend on the transaction and personal preferences. If the business is held by an entity, like a corporation or an LLC, then there are two general ways to transfer it: an asset sale or a stock sale. In an asset sale, the seller sells the business, asset by asset, which are listed in the agreement. In a stock sale, the buyer simply buys the corporate stock or the LLC membership interest, and all the assets stay in place, as those are owned by the corporation or LLC. Buying the stock means you take all assets along with the liabilities. Buying assets means you can negotiate which assets and liabilities to transfer. Generally speaking, buyers want asset purchases, sellers want stock sales. Make sure you're clear regarding what the assets are. Perhaps the seller is selling everything, but doesn't want to transfer the company car. Perhaps there's software involved that isn't being sold, but perhaps only licensed. Maybe seller is taking an employee with him. Be sure that if there are building or equipment leases, those are being assigned or can be renegotiated. Perhaps the lease negotiation is a contingency to closing. Regarding the structure, sellers want cash, though some sellers may want the deal structured a certain way for tax purposes. Buyers want to hold certain cash back for a certain period of time in case there are any problems with the business that the seller has promised to take care of after the deal has closed. Sometimes this is a promissory note or an amount held by a third-party escrow. Buyer is going to want a non-compete. That's customary, and sellers usually agree to some form of that. Sometimes the seller gets sued after the business is transferred, and it's a claim that is based on events occurring on the seller's watch. A purchase agreement often has language in it called an indemnity, which provides for some kind of reimbursement from the seller for buyer having to pay for something that wasn't the buyer's fault or that allocated fault to the seller. Seller may have made certain representations regarding the business that turned out not to be true. As a result, seller may be responsible to pay for any claim made against the buyer. This could include claims concerning third-party vendors, customers, taxing authorities, hazardous materials, or employees, to name a few. In summary, both parties will want to discuss the terms under an NDA and perhaps sign an LOI. Following that, define the structure of the payment, define the assets to be transferred and not transferred, same with the liabilities. Figure out how you're going to deal with issues like employees, taxes, and non-competes, then allocate risk in your indemnification, representations, and warranties. There's a lot to deal with and think about. No two deals are the same. Be prepared.